know, like most Americans, I'm not a lawyer. I bring a slightly different perspective onto this committee. But one thing is very important to me, and it's something that matters to Iowans, whether they are lawyers or not. I firmly believe in the role of our Supreme Court. It is the defender of our Constitution. At the end of the day, that's my test for a Supreme Court justice. Will you defend the Constitution? It frustrates me and it frustrates my fellow Iowans that the Supreme Court has become a super legislature for a Congress that frankly won't come together, discuss these tough issues, and do its job. What I hear from my colleagues on the left is about judicial activism and what they want to see in their nominees, which is that super legislature. They are projecting that upon you, Judge Barrett. That's what they are projecting as they talk about what cases may or may not come in front of the Supreme Court. Matter of fact, I think it was just the other day that Vice President Joe Biden told the American people they don't deserve to know whether he is going to pack the court. They don't deserve to know who his judicial nominees would be. I think we do need to know, again, because it's what the left is projecting on you today, is what they want to see in their nominees. But that's not what our founders intended the court to be. I hope that this hearing will be an open, fair conversation about how Judge Barrett would be as Justice Barrett. I am concerned, however, that not everyone involved in this hearing shares that goal. We've already seen hints in that over the past few weeks, immediately attacking your faith and your precious family. Instead of entering into this nomination process with an open mind and a desire to understand this woman who has been nominated for the highest court in the land, the focus is on a plan or a strategy, a series of tactics to undermine, coerce, and confuse the American people. A plan, Judge Barrett, to undermine you as a person, undermine your family, and undermine what you hold dear. Women all over the world are painfully familiar with this strategy. We are all too often perceived and judged based on who someone else needs or wants us to be, not on who we actually are. I cannot speak for those that would attempt to undermine your nomination, but as a fellow woman, a fellow mom, a fellow Midwesterner, I see you for who you are. And I'm glad the American people have the opportunity to get to know Amy Coney Barrett. This week will be an opportunity to dig into your background further and understand more about your judicial philosophy. But what your political opponents want to paint you as is a TV or cartoon version of a religious radical, a so-called handmaid that feeds into all of the ridiculous stereotypes they have set out to lambast people of faith in America. And that's wrong. It might be less comical if this was the first time the left has trotted out this partisan playbook. Your political opponents have made these types of religious attacks on nearly every Supreme Court candidate nominated by a Republican president in the modern era. And every time, like clockwork, they say they really mean it this time. This nominee, this woman in front of us, she is the absolute worst. I'm struck by the irony of how demeaning to women their accusations really are. That you, a working mother of 7, with a strong record of professional and academic accomplishment couldn't possibly respect the goals and desires of today's women. That you, as a practicing Catholic, with a detailed record of service, lack compassion. I know you to be compassionate. Your record on the Seventh Circuit says that you are. And more importantly, it shows that your demonstrated commitment is to defending the Constitution. The great freedom of being an American woman is that we can decide how to build our lives, whom to marry, what kind of person we are, and where we want to go. I served in the Army, something not exactly popular at various points in America's history. We don't have to fit the narrow definition of womanhood. We create our own path. Justice Ginsburg was one such woman, and I would like to pay tribute to her for what she did to pave the way for women of today. It's really quite simple what your opponents are doing. They are attacking you as a mom and a woman of faith because they cannot attack your qualifications. Every year, I travel to every single one of Iowa's 99 counties and talk to men and women from all walks of life. Whether they are farmers or nurses or small business owners, they want a government that is accountable to them. When Congress makes a law that oversteps the Constitution, the ripples can be felt, whether it's on farms in Montgomery County, where I'm from, and the manufacturing facilities of Dubuque. It can be felt in the church services of Sioux City and the community meetings in Waterloo. The Supreme Court's only job is to rule on the cases before it and defend the Constitution. To do that well, a justice needs to be thoughtful, restrained, and wise. Judge Barrett, so far I have seen all of those things in you. I am so glad that we have you in front of us. I look forward to learning more about you. I want to thank you and your family for being in this nomination today. And certainly, this, folks, is what a mom can do. Thank you, Judge Barrett, very much. Thank you, Mr. Chair.
Senator Booker.
Thank you, Mr. Chairman. Behind me, Merritt Bowman is a 49-year-old father of twin boys, which you could see, and a football coach and paraprofessional at Deptford High School in New Jersey. For years, Merritt put off going to the doctor because he was, like many Americans, afraid he could not afford it. But when the Affordable Care Act was passed, he finally got the coverage he could afford. 4 years ago, after not feeling well, Merritt made the doctor's appointment and was diagnosed with type 2 diabetes, a disease that affects over 10% of Americans and disproportionately impacts Black Americans like Merritt, who are 60% more likely to be diagnosed with diabetes and twice as likely to die from it. Today, Merritt takes insulin and other medications, and his condition has thankfully improved. Merritt said, and I quote, "Obamacare made it so I was not afraid of the costs of going to the doctor. If I didn't have insurance and didn't get diagnosed, who knows where I would be right now." But Merritt is worried about what will happen if the Affordable Care Act gets overturned. He said, and I quote, "Now I have a pre-existing condition. My insurance covers my medications, my equipment to monitor my diabetes. If that's taken away from me, what's going to happen? I can't afford those on my own." Michelle Luris from Palisades Park, New Jersey, lost her husband, John, last year when he passed away suddenly at the age of 58. Michelle relied on health insurance through John's job, but when he died, their insurance went away. She was given the option to continue his plan, but she couldn't afford the cost of $800 a month. So Michelle signed up for coverage on the insurance marketplace, where she qualified for a subsidy that made it more affordable. Today, she's insured and she can manage her diabetes, heart disease, and an autoimmune disease because of her coverage. Like Merritt, Michelle also relies on insulin, and other prescription medications. If the ACA was overturned, Michelle said, quote, "I could lose my house if I didn't have affordable health care. I would have to sell my home. I like where I live. I don't want to lose my home." People like Barrett and Michelle are understandably scared right now. President Trump has told America he would end the ACA. He promised explicitly that he would only nominate judges that would do the right thing and eliminate the Affordable Care Act. People like Barrett and Michelle know what a future without the ACA looks like. It looks like 130 million Americans with pre-existing conditions, from cancer survivors to people with disabilities, being charged more or denied coverage completely. It looks like 20 million Americans losing their access to potentially life-saving care in the middle of a pandemic that's already killed over 214,000 Americans. In New Jersey, we've lost over 16,000 people to COVID-19. 595,000 people would lose their coverage without the ACA. For millions of Americans, a future without the ACA looks like being forced to sell your house if you can't afford your health care. It looks like not having access to a doctor when you're sick. It looks like having to choose between paying for groceries and paying for medicine. And people are scared right now for another reason, because they know what a future without the protections of Roe v. Wade looks like, because President Trump has explicitly stated that he would only put up Supreme Court nominees that would overturn Roe v. Wade. He said it clearly. We should believe him. And that, without Roe v. Wade, our country looks like people being denied the ability to make decisions about their own bodies, not just while they're pregnant, but being stripped of the right to plan for their futures. It looks like women of color, low-income women, and women living in rural areas who can't just pack up and leave if abortion is restricted or criminalized where they live. It looks like them being left with no options. It looks like state laws proliferating throughout our country that seek to control and criminalize women. It looks like the government interfering with women making the most personal medical decisions. It looks like a country in which states may write laws that could subject women who have miscarriages to investigations to ensure they didn't have abortions. In America today, people are scared. You've heard from my colleagues, we're getting calls to our office where people are afraid. More than 214,000 Americans have died, many of them isolated and alone, away from friends and families. Tens of millions of jobs have been lost. 1 in 3 American families with children aren't getting enough food to eat. More than 100,000 small businesses have closed permanently. Lines at food banks in the wealthiest nation on the planet have stretched for miles. We could be, as the Senate, we should be, as the Senate, working in a bipartisan way to try to get this virus under control, to get relief to people who are hurting, who are struggling, who are afraid, to help people who are unemployed, to let doctors and nurses and hospital staffs putting their lives on the line right now in state after state where COVID is rising, know that we have their backs in a pandemic. But instead of doing anything to help people who are struggling right now, we are here. We're here. I'm so glad, I'm really glad that my colleagues who contracted COVID-19 at the Rose Garden Super Spreader event for Judge Barrett had access to the care that you and your families needed. That is right. This is a blessing. The problem is the people who will come through here today to wipe down the desks and empty the garbage, that will vacuum the floor, like people all over our country who are working today in factories, teaching children in schools. They don't have direct line to the nation's top health experts. They can't show up to work sick, and they might not have space to distance themselves at home to protect their families. We literally stopped the Senate from functioning with the exception of this hearing. That's why we're here. We're not just 22 days from an election. We're in the middle of an ongoing election when millions of people have already started voting because Donald Trump and most of my Senate Republican colleagues know the truth. They won't be able to get away with this after the American people have spoken in this election. Donald Trump and my Senate Republican colleagues in this room today know that the American people don't want the ACA overturned. Donald Trump and my Senate Republican colleagues know that the majority of Americans actually don't want Roe v. Wade overturned, that the majority of Americans don't want to see abortion criminalized in our states. But that is exactly why we are here today, because Donald Trump and Senate Republicans know that the American people don't want this, so they have to act now. They don't trust the American people, which is so painful because that's what they said. They said we should trust the American people, and what the American people say under President Obama 269 days from an election. And then, after that election, they tried time and time again to overturn the Affordable Care Act, but a handful of Republicans stopped them. You see, they tried in the Senate, they tried in the House, over 70 attempts to rip down the Affordable Care Act, but now Donald Trump has said explicitly he's going to do it through the courts by making the nomination we see here today. That's why we are here. The American people should know that that is what this is all about, rushing this nomination through to sit a Supreme Court justice in time to hear a case before the Supreme Court that will end the Affordable Care Act. We're here because in the middle of a deadly pandemic, in the middle of an ongoing election, Senate Republicans have found a nominee in Judge Barrett who they know will do what they couldn't do, subvert the will of the American people and overturn the ACA and overturn Roe v. Wade. That's what this is about. That's why we're here. It's very simple. Senate Republicans know the American people don't want this, but they don't care because they have only one small window of opportunity to work the system, betray what the American people want. And so they're desperately rushing to complete this process before America starts voting, but they don't have to do this. If one of my colleagues will stand up on this committee, we can hold this over until after an election. If two of my colleagues on the Senate floor agree with their other two colleagues, Republicans, we can stop this. Otherwise, this is a charade when they say this is a normal Judiciary Committee hearing for a Supreme Court nomination. There's nothing about this that's normal. It's not normal that Senate Republicans are rushing through a confirmation hearing, violating their own words, their own statements, betraying the trust of the American people and their colleagues, and failing to take in this hearing even the most basic safety protections to protect people around them, all to ensure that tens of millions of people will lose their health care when we're 7 months into one of the worst public health crises in the history of our country. It's not normal. This is not normal that millions of Americans like Michelle and Barrett are just scared of a deadly virus. They're scared of their fellow Americans who are sitting in this room right now. They're scared that their government and their institutions will be manipulated by people who could not work through the democratic process to take away their health care and are trying an end run to achieve that. Nothing about this today is normal. This is not normal. What is going on in America today, in the midst of a deadly pandemic and an ongoing election, having a rushed Supreme Court nomination hearing is not normal, and we cannot normalize it. People are voting right now. The American people should decide. The American people should decide. The American people should decide. I will not be voting to confirm Judge Barrett's nomination.
Thank you. Senator Crapo.
I would like to submit a letter for the record, if I may. We should not be rushing, as I said, this process. My colleagues agree with me that we should be working to protect the health and safety of Americans across the country and taking the precautions, greater precautions in this workplace. I'd like to enter into the record a letter from Senators Leahy, Senator Harris, and myself that we sent to the chairman last week asking that these hearings not proceed without proper testing measures, without all of us being tested and a COVID safety protocol being put into place.
Thank you. Without objection. Senator Crapo.
Thank you, Mr. Chairman. And Judge Barrett, welcome and congratulations on the high honor of your nomination. I have some prepared remarks here, which I will give, but having sat through the speeches that I've heard already and listened to the attacks that have been made, both on Republican members of the committee and on you, I think it's important to just set the record straight on a few items before I then talk about why we are here, and that is you and your qualifications to serve as a justice. So what were the attacks? I'd say the first one is that we're rushing too fast and that we are violating the rules and norms and precedents of the Senate and speeding into these proceedings. What are the facts? Well, I had my staff check while we were sitting here. This hearing is 16 days after Judge Barrett's announced nomination. More than half of all Supreme Court hearings have been held within 16 days of the announcement of the nominee. This case is no different. A couple of examples. Justice Stevens, 10 days. Justice Rehnquist, 13 days. Justice Powell, 13 days. Justice Blackmun, 15 days. Justice Berger, 13 days. These proceedings are following right along in the same kind of process that has historically been the process of the Senate. So then the argument is made that, well, this is an election year, and the Republicans said back in 2016 that in an election year they wouldn't move forward with then President Obama's nomination. What are the facts? A vacancy has arisen in a presidential election year 29 times. Every single one, and this is important to note, every single one of those 29 times, whoever was the sitting president made a nomination to replace the vacancy, to fill the vacancy. Every one of those 29 times. 19 of those 29 times, the parties of the president and the Senate majority were the same. And 17 of those 19 nominees were confirmed. By contrast, of the 10 times in which the Senate was controlled by the party opposite to the president, only one time did the Senate that was not of the party of the president proceed to fill that vacancy. In fact, vacancies under a divided government, meaning a Senate and a presidency from different parties, have not been filled for over 130 years, going back to 1888. So much like when the Senate exercised its constitutional right, fully consistent with precedent in 2016, not to fill the vacancy when there was divided government, the Senate is today exercising its duty to move forward with processing this nomination, just like the vast majority of Senates in the past have done every time this has happened. And it's important to note that. Any claim that this process is unusual or that it violates the clear precedent of the Senate is simply false. So then, back to the attacks on the members of this committee on the Republican side, and frankly against the president, it says that we're trying to engage in court packing. Now, that's a novel one because it's actually the Senate following standard procedure with regard to a vacancy that is now being accused of being court packing, when my colleagues on the other side are actually proposing court packing. That is, to statutorily and with the signature of a president, change the law so that they can add more members to the court. FDR tried this, and his effort was rejected. That effort should be rejected now, but let's be clear about it. This is not court packing. That, threatening to pass a law and change the court, is court packing. So then what were the arguments that were actually leveled against Judge Barrett? Well, the standard arguments. She is going to overturn all protections for women. She is going to change all of the laws in the country that protect people's health care. And everyone in this country who has a pre-existing condition or has any kind of a worry about getting support needs to worry that she's going to be an activist judge and a justice and go in there and change the law. She's not, and we all know that. This is simply the tired, worn-out argument that is constantly made every time a Republican president nominates a candidate for the bench for the Supreme Court of the United States. And it's never been true, and it will not be true with Judge Barrett. So then the attack is, well, the Republicans don't care about people's health. They won't even try to get COVID relief out. And we're here in a hearing in the Judiciary Committee when we ought to be passing COVID relief legislation. And I've heard several of my colleagues basically say the Republicans are refusing to work on helping to address the COVID crisis. This coming from colleagues who just a month or so ago voted unanimously to filibuster a $500 to $600 billion COVID relief package in the Senate. A COVID relief package, I asked my staff to get me a quick summary of it, that put, as I indicated, somewhere between $500 and $600 billion into more small business loans, unemployment insurance, agriculture and farming assistance, postal service assistance, education assistance, both at the higher education levels and at K through 12, healthcare assistance for pandemic preparation, for strategic stockpiles, for testing, for contact tracing, billions for vaccine and therapeutic and diagnostic development, and the list goes on. We were stopped from proceeding with this legislation by a filibuster of those who now accuse us of not wanting to try to do something. We stand ready if you'll simply let us go to the legislation and pass it. So now, Judge Barrett, let me talk about you. Judge, you have an exemplary academic record and legal credentials, and you are preeminently qualified to serve on our Supreme Court. Following your graduation from law school, you clerked for both the U.S. Court of Appeals for the District of Columbia and the U.S. Supreme Court. At the Supreme Court, you clerked, as everyone knows, for none other than the late Justice Antonin Scalia. Upon receiving your nomination to the Supreme Court, Judge Barrett reflected on her clerkship for Justice Scalia, citing his incalculable influence on her life. She also stated that his judicial philosophy is hers too, and that a judge must apply the law as written. That's what we need in our next Supreme Court justice. Rather than the activist justice that you are being accused of being. Judges are not policymakers, and they must be resolute in setting aside policy views that they may hold. And I know you know that. Should we not take Judge Barrett at her word? As a judge, Supreme Court or otherwise, she must be dedicated to interpreting the law as written with an unparalleled commitment to our Constitution. I've visited with her privately. I've reviewed her record. I have seen nothing that would indicate that she is not telling the truth when she says that is her view of how a judge should conduct herself. I've met with a number of Supreme Court nominees in my service in the Senate, and throughout I've continued to maintain an emphasis on following the law and upholding our Constitution, and that must be a central characteristic of the justices we select for this highly influential part of our government. Judges have a great responsibility to carefully exercise their authority within the limits of the law. Our court system has the responsibility to preserve our constitutional rights, ensure a limited government, and provide speedy and fair justice. Following her clerkships, Judge Barrett spent time in private practice before beginning her tenure as a professor. Her academic scholarship and lengthy analysis of issues facing the federal courts make her uniquely well qualified to serve on our nation's highest court. In particular, Judge Barrett's thoughtful exploration of the precedent and the doctrine of stare decisis demonstrates that she is both intellectual and deliberative in her understanding of the law. Moreover, it's evident that she understands the role of a fair and proper judge. In September 2017, Judge Amy Coney Barrett came before the Senate Judiciary Committee, this committee, after being nominated to the U.S. Circuit Court of Appeals for the Seventh Circuit. During that hearing, she repeatedly expressed her commitment to independent and unbiased decision-making. I was proud to support her confirmation to the Court of Appeals in both the committee and on the Senate floor. Judge Barrett's remarkable resume shows she is a pioneer in the legal field. She will be the 5th woman and the first mother of school-age children to serve on the Supreme Court. In many ways, she's the ideal candidate to fill this current vacancy. Mr. Chairman, I look forward to hearing more from the nominee about her experience and her judicial philosophy. The next few days will prove invaluable as we discuss with Judge Barrett at length the proper role of a judge in our legal system. I look forward to this hearing. Thank you, Mr. Chairman.
Thank you. I believe Senator Harris.
Can you hear me?
Yes, hello.
Hello?
We hear you.
Chairman, this hearing has brought together more than
well,
50 people
Just,
to sit inside a room for hours, a
Senator-
closed door. Yes,
just wait just 1 second. We don't see you.
of course. You don't see me.
One, congratulations on being on the ticket. I hadn't told you that. There we go. All right.
Can you see me now?
Yeah, I can see you now, hear you loud and clear. The floor is yours.
Mr. Chairman, can you see me and hear me?
I see you, I hear you. The floor is yours.
Okay, I appreciate it. Thank you, Mr. Chairman. This hearing has brought together more than 50 people to sit inside of a closed-door room for hours while our nation is facing a deadly airborne virus. This committee has ignored common sense requests to keep people safe, including not requiring testing for all members, despite a coronavirus outbreak among senators of this very committee. By contrast, in response to this recent Senate outbreak, the leaders of Senate Republicans rightly postponed business on the Senate floor this week to protect the health and safety of senators and staff. Mr. Chairman, for the same reasons, this hearing should have been postponed. The decision to hold this hearing now is reckless and places facilities workers, janitorial staff, and congressional aides and Capitol Police at risk. Not to mention that while tens of millions of Americans are struggling to pay their bills, the Senate should be prioritizing coronavirus relief and providing financial support to those families. The American people need to have help to make rent or their mortgage payment. We should provide financial assistance to those who have lost their job and help parents put food on the table. Small businesses need help, as do the cities, towns, and hospitals that this crisis has pushed to the brink. The House bill would help families and small businesses get through this crisis. But Senate Republicans have not lifted a finger for 150 days, which is how long that bill has been here in the Senate, to move the bill. Yet, this committee is determined to rush a Supreme Court confirmation hearing through in just 16 days. Senate Republicans have made it crystal clear that rushing a Supreme Court nomination is more important than helping and supporting the American people who are suffering from a deadly pandemic and a devastating economic crisis. Their priorities are not the American people's priorities. But for the moment, Senate Republicans hold the majority in the Senate and determine the schedule. So here we are. The Constitution of the United States entrusts the Senate with the solemn duty to carefully consider nominations for lifetime appointments to the United States Supreme Court. Yet the Senate majority is rushing this process and jamming President Trump's nominee through the Senate while people are actually voting, just 22 days before the end of the election. More than 9 million Americans have already voted, and millions more will vote while this illegitimate committee process is underway. A clear majority of Americans want whomever wins this election to fill this seat. and my Republican colleagues know that. Yet, they are deliberately defying the will of the people in their attempt to roll back the rights and protections provided under the Affordable Care Act. And let's remember, in 2017, President Trump and congressional Republicans repeatedly tried to get rid of the Affordable Care Act. But remember, people from all walks of life spoke out and demanded Republicans stop trying to take away the American people's health care. Republicans finally realized that the Affordable Care Act is too popular to repeal in Congress. So now they are trying to bypass the will of the voters and have the Supreme Court do their dirty work. That's why President Trump promised to only nominate judges who will get rid of the Affordable Care Act. This administration, with the support of Senate Republicans, will be in front of the Supreme Court on November 10th to argue that the entire Affordable Care Act should be struck down. That's in 29 days that that'll happen. And that's a big reason why Senate Republicans are rushing this process. They are trying to get a justice onto the court in time to ensure they can strip away the protections of the Affordable Care Act. And if they succeed, it will result in millions of people losing access to health care at the worst possible time, in the middle of a pandemic. 23 million Americans could lose their health insurance altogether. If they succeed, they will eliminate protections for 135 million Americans with pre-existing conditions like diabetes and asthma, heart disease, or cancer, a list that now will include over 7 million Americans who have contracted COVID-19. Insurance companies could deny you coverage or could sell you a plan that won't pay a dime toward treating anything related to your pre-existing condition. If the Affordable Care Act is struck down, you will have to once again pay for things like mammograms and cancer screenings and birth control. Seniors will pay more for prescription drugs, and young adults will be kicked off of their parents' plans. And these are not abstract issues. We need to be clear about how overturning the Affordable Care Act will impact the people we all represent. For example, Micah, who is 11 years old, and she lives in Southern California. So Micah enjoys being a Girl Scout, and ice skating, and reading, and eating pasta, and baking. Her mother says the only reason Micah is able to live her life as she does now is because the Affordable Care Act guarantees that her health insurance cannot deny her coverage or limit her care because it's too expensive. You see, Micah has a congenital heart defect. She goes to multiple specialists throughout the year and gets an MRI with anesthesia every 6 months. At just 11 months old, Micah's family had already hit $50,000 in medical expenses, and her biannual MRI cost were $15,000 a session. And so, correction, by 11 months old, her family had hit $500,000 in medical expenses. If Republicans succeed in striking down the Affordable Care Act, insurance companies will be able to deny coverage for children with serious conditions, children like Micah. And parents, well, they'll be on their own. No one should face financial ruin to get their child or their spouse or their parent the care they need. And no family should be kept from seeing a doctor or getting treatment because an insurance company says that the treatment is too expensive. In America, access to health care should not be determined based on how much money you have. Health care and access to health care should be a right. Micah and millions of others who are protected by the Affordable Care Act know this is fundamentally what is at stake with this Supreme Court nomination. And of course, there's more at stake. Throughout our history, Americans have brought cases to the United States Supreme Court in our ongoing fight for civil rights, human rights, and equal justice. Decisions like Brown versus Board of Education, which opened up educational opportunities for Black boys and girls. Roe versus Wade, which recognized a woman's right to control her own body. Loving v. Virginia, and Obergefell v. Hodges, which recognized that love is love, and that marriage equality is the law of the land. The United States Supreme Court is often the last refuge for equal justice when our constitutional rights are being violated. Justice Ruth Bader Ginsburg devoted her life to fight for equal justice, and she defended the Constitution. She advocated for human rights and equality. She stood up for the rights of women. She protected workers. She fought for the rights of consumers against big corporations. She supported LGBTQ rights, and she did so much more. But now, her legacy and the rights she fought so hard to protect are in jeopardy. By replacing Justice Ruth Bader Ginsburg with someone who will undo her legacy, President Trump is attempting to roll back Americans' rights for decades to come. Every American must understand that with this nomination, equal justice under law is at stake. Our voting rights are at stake. Workers' rights are at stake. Consumer rights are at stake. The right to a safe and legal abortion is at stake. And holding corporations accountable is at stake. And again, there's so much more. So, Mr. Chairman, I do believe this hearing is a clear attempt to jam through a Supreme Court nominee who will take health care away from millions of people during a deadly pandemic that has already killed more than 214,000 Americans. I believe we must listen to our constituents and protect their access to health care and wait to confirm a new Supreme Court justice until after Americans decide who they want in the White House. Thank you.
Thanks, Senator Harris. Senator Kennedy.
You have a beautiful family, Judge. We claim you in Louisiana. We're proud of the fact in Louisiana that you were born in Metairie, a suburb of New Orleans. We're proud of the fact that you got a solid education at St. Mary's Dominican High School. Come back and visit us. I know your mom and dad still live there, and we're very proud of you and your career. This is a solemn occasion, as it should be. I can't think of another position, at least not a position that is for life, not a position in which the occupant is not elected by the people, that is more powerful, at least not in the Western world, than an Associate Justice of the Supreme Court. And this process is not supposed to be the big rock candy mountain. Our job is to advise and consent. And that's one way of saying that we're supposed to make sure that the president hasn't, whatever president makes the nomination, hasn't made a mistake. And we all, as you can see, take that job seriously, as you can see, and we know you respect that. That's why I think over the next several days it's appropriate for us to talk about your intellect, which is obvious, by the way, and your temperament, your character, and your judicial philosophy. And I hope we can talk about something else. And that's the role of the federal judiciary in American life. Now, look, Judge, I'm not naive. I understand this thing can turn sour real fast. We all watched the hearings for Justice Kavanaugh. It was a freak show. It looked like the cantina bar scene out of Star Wars. And I know for someone unaccustomed to it that it hurts to be called a racist. I think it's one of the worst things you can call an American. I know that it hurts to be called a white colonialist, and I know it must hurt for someone of deep Christian faith like yourself to be called a religious bigot, and to have it implied that because you are a devout Christian, that you're somehow unfit for public service. Before it's over with, they may call you Rosemary's Baby, for all I know. I hope not. And I know, as we've seen this morning, I know you think it's unfair. It is unfair for my colleagues to suggest, some overtly, some more indirectly, that if you're put on the United States Supreme Court, you will be on a mission from God to deny health care coverage for pre-existing conditions for every American. I know that seems preposterous to you, and it seems that way because it is. Take comfort in the fact that the American people, some of my colleagues disagree with this statement. They believe in government. I believe in people. The American people are not morons. They can see drivel when they see it, and they can appreciate it when they see it for being what it is. Now, let me turn to what I hope quickly we can talk about today. Americans love democracy. We'll even fight for it, and we have. And that's a wonderful thing. It's an important thing in today's world as this world becomes more authoritarian. And our founders, but we don't have a pure democracy. As a columnist I read this morning said, when we have to decide a complex issue dealing with social norms or economic issues, we don't all put on a toga and go down to the forum and vote. We have elected representatives. Those are members of Congress. And it is our elected representatives' job to decide social and economic policy. And if we don't like what they do, they're accountable. We vote them out. But in the last 50 years, certainly in the last 25, the United States Congress, either voluntarily or involuntarily, has ceded a lot of its power to the executive branch and to the federal judiciary. When I say the executive branch, I'm not necessarily talking about the president. I'm talking about the administrative state, the bureaucracy, as some call it. It's this giant rogue beast that enjoys power now that only kings once enjoyed. Members of the administrative state write their own laws. They interpret their own laws. They litigate their own laws in their own courts before judges that they appoint. And Congress has allowed that to happen. I think Congress has also abdicated a lot of power to the federal judiciary. I do. And I'm not saying that federal judges don't make law. Of course they make law. They make law in the context of a specific case. It's called judicial precedent. But our founders intended federal judges to exercise judicial restraint and to understand the special role, scope, and mission of the federal judiciary vis-a-vis the United States Congress. I don't think our founders intended judges to be politicians in robes. I think our founders intended judges, federal judges, to tell us what the law is, not what the law ought to be. I think our founders intended, as the Chief Justice put it, I think our founders intended federal judges to call balls and strikes. I don't think our founders intended for federal judges to be able to redraw the strike zone. I don't think our founders intended for judges to be politicians in robes. Politicians, You don't want the United States Supreme Court to turn into this. Trust me. Politicians get to vote their preferences under our democracy. Judges do not. Judges do not. And finally, unlike some of my colleagues, I don't think our founders intended the United States Supreme Court to become a mini Congress. I don't think our founders intended members of the United States Supreme Court to try to rewrite our statutes or the United States Constitution every other Thursday because to prosecute a social or an economic agenda that they can't get by the voters. And that goes on in America every day. We've reached the point where one single solitary federal judge in a limited venue can enjoin a federal statute or an executive order of the President of the United States for the entire country. And our founders never intended that. I want to close with two very short quotations. The first, stated much more eloquently than I can, is Justice Curtis in 1857. You probably read it. He was dissenting in the Dred Scott case. This is what Judge Curtis said. When a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, we have no longer a Constitution. We're under the government of individual men who, for the time being, have power to declare what their Constitution is according to their own views of what it ought to mean. And finally, a more contemporary statement from a gentleman that you're very familiar with, Justice Scalia. He said it in real world terms. This is what he said. The American people love democracy, and the American people are not fools. The American people know their value judgments are quite as good as those taught in any law school, maybe better. Value judgments, after all, should be voted on, not dictated. Thank you, Mr. Chairman.